something feels off. And if you're currently in the middle of an I-485 application, or you're planning to file one soon, pause what you're doing and watch this entire video. Because over the past several months, USCIS procedures, internal workflows, and public guidance have continued to evolve in ways that can change how adjustment of status cases are reviewed, prioritized, and sometimes denied. And many applicants don't realize how much small changes in process can affect real outcomes. We're talking about longer and more variable processing times, more frequent requests for evidence in some case types, biometrics appointment delays in certain locations, and shifting expectations about what documentation is complete and persuasive. Any of this can catch filers off guard in 2026 if they rely on outdated checklists, old form editions, or advice that doesn't match current USCIS practice. In this video, I'm going to walk you through the key areas to watch, who may be impacted, what appears to be changing, and most importantly, what you can do right now to reduce risk and avoid preventable delays. Don't click away. For many people, these details really can influence whether a case moves smoothly or becomes complicated. Welcome to US Entry Updates. If you're new here, this channel is dedicated to clear, unbiased, and fact-based immigration analysis. We don't promote rumors, panic, or insider leaks. We focus on what can be supported by official USCIS resources, published policy guidance, federal court decisions, and verified legislative developments. And just as importantly, we explain what is known, what is uncertain, and what depends on the facts of your specific case. Quick note, this video is general information, not legal advice. Immigration cases are highly fact-specific, and if you need advice for your situation, speak with a qualified immigration attorney or an accredited representative. Now let's start from the beginning. What exactly is the I-485, and why does the current environment make filing it feel more complicated than it did a few years ago? Form I-485, application to register permanent residence or adjust status, is the central filing for someone seeking a green card while already inside the United States. It's how you transition from a temporary status, whether that's H-1B, F-1 OPT, K-1 fiancé, TPS, asylum-based pathways, or other categories, into lawful permanent resident status if you're eligible. And when an I-485 goes wrong, the consequences can be more than paperwork. Depending on your situation, problems can affect work authorization, travel plans, and your ability to remain in the United States. In some cases, a denial may also raise enforcement or removal concerns, especially if someone has no other valid status or protection. This is not a form to file casually, and in 2026, it is definitely not a form to file without confirming that you're using current forms, current instructions, and a complete, well-documented package. Here's what's going on in broad terms. USCIS continues to manage high application volume, shifting staffing needs, and changing internal priorities. That can affect how field offices and service centers triage and adjudicate I-485 cases. At different times, USCIS leadership has emphasized different priorities, including careful review of supporting documentation, consistency across employment-based filings, and scrutiny of eligibility issues that can be triggered by prior immigration history. What that means in practical terms is simple. Tolerance for mistakes can be lower, the documentation expectations can feel higher, and timelines can be less predictable than people assume, especially if they're relying on older experiences from friends, online forums, or videos that don't reflect current practice. Now this is where things become especially important. One area that can create trouble is concurrent filing. When someone files the I-485 at the same time as the underlying petition, like an I-130 or an I-140, when permitted. For many applicants with current priority dates or immediate eligibility, concurrent filing can be efficient, but it also means your entire package has to be clean, current, and complete at intake. If something fundamental is missing, USCIS may issue an RFE, and in some situations the package can be rejected at intake and returned before a receipt notice is issued. And if a package is rejected and someone's underlying status is close to expiring, that gap can create serious complications. Not every case becomes a crisis, but the risk is real enough that you should treat intake accuracy as a priority. Let me put a human face on it, because immigration law can feel abstract until it hits a family. Think about Maria. Maria isn't one specific person, but she represents a scenario we see often. She came to the United States from the Philippines on H-4 status tied to her spouse's H-1B. Her spouse's employer filed an I-140. It was approved, and their priority date became current. They prepared the I-485 package themselves using online guides, and they filed with documents they believed were correct. Several weeks later, instead of receiving a receipt notice, they received a rejection notice. The issue involved a support document that didn't match current requirements and supporting evidence that didn't meet what USCIS was expecting based on the latest instructions and guidance. They had to refile. During that time, Maria's situation became stressful because timing mattered, and they needed individualized legal guidance to ensure they didn't create avoidable status problems. The point is not to scare you. The point is that many rejections and RFEs are preventable when you verify the latest requirements and submit a fully documented package the first time. Now here's what many people misunderstand about the I-485 process in 2026. A lot of applicants believe that if their priority date is current and the underlying petition is approved, adjustment of status is basically routine. That assumption can be risky. USCIS has continued to clarify and update expectations about what it considers complete and sufficient. Their policy manual and form instructions can emphasize evidence for eligibility elements like lawful admission, continuous eligibility where required, and accurate disclosure of immigration history. That includes issues like overstays, unauthorized employment, prior removal orders, and other events that can matter depending on the category and the person's specific facts. Some issues are waivable, others are not, and some depend on exceptions. But the key is this: USCIS expects accurate disclosure and proper documentation. Also, the form edition matters. If you submit an outdated edition of Form I-485, USCIS can reject the filing at intake. Don't rely on a form you downloaded months ago or received from someone else. Always pull the current edition directly from uscis.gov and confirm the edition date shown on the USCIS form page matches what you're filing. There's another layer here: the intersection of adjustment of status with legislation, litigation, and executive action. Let's be precise, because this is where misinformation spreads fast. As of 2026, Congress may be considering various immigration-related proposals at different times, including ideas that could affect adjustment procedures, eligibility rules, and how certain statuses or parole programs interact with I-485 eligibility. But proposals are not laws. A bill introduced, marked up, or passed in one chamber does not become law unless it passes both the House and Senate in identical form and is signed by the President. And in the Senate, many major bills face significant procedural hurdles, often including the practical need to reach a 60-vote threshold to move forward. So yes, proposals matter, but timelines are uncertain, and many proposals never become law. However, here's what is important right now. USCIS can change procedures and evidentiary expectations through policy guidance and operational updates under its delegated authority. Some changes go through formal rulemaking with notice and comment under the Administrative Procedure Act. Others are implemented through policy updates, revisions to form instructions, and internal process changes. That means real-world requirements can shift even when Congress does nothing. This is why it's so important to rely on current official sources, not old checklists. Now let's talk about employment-based green cards, because this is where I see a lot of confusion and avoidable risk in 2026. If you are an H-1B worker with an approved I-140 and you're waiting for your priority date to become current, the Visa Bulletin can create windows of opportunity. Sometimes those windows open quickly, and that creates urgency. But urgency leads to mistakes. Filing fast can matter, but filing correctly matters more. Backlogs remain severe for some countries in certain categories, while other countries may see faster movement at times. The key takeaway is that the Visa Bulletin can move forward, and it can also regress. So you need to plan carefully, verify which chart USCIS is using for filing that month, and avoid filing based on assumptions. This next part can affect you even if you think it doesn't. A frequent issue for employment-based applicants involves AC-21 portability. Under AC-21, some I-485 applicants with a pending adjustment application for at least 180 days may be able to change employers and continue the green card process. as long as the new job is in the same or a similar occupational classification. Many people rely on that protection, but USCIS may request more detailed evidence to prove same or similar. In some cases, a simple employer letter is not enough. Applicants may be asked for detailed job duties, SOC/O** net comparisons, wage information, and other documentation that supports the similarity analysis. If you anticipate using portability, plan ahead and keep strong documentation ready so you're not scrambling under a deadline. Here's another example to make it concrete. Think about David. David came from Nigeria on an F1 visa, completed a master's in computer science, worked through OPT and STEM OPT, then moved to H1B. His employer filed an EB2 I-140. It was approved. His priority date became current, and he filed his I-485. After years in the system, he was understandably hopeful. Then his company had layoffs, and he lost his job. He found a new role that he believed was similar and relied on AC-21 portability. Later, USCIS issued an RFE asking for a detailed same or similar analysis. David tried to respond without legal help, but the response didn't fully address what USCIS was asking for. He then received a notice of intent to deny and had limited time to submit a stronger response. Again, the goal here isn't fear. It's preparation. If you know what USCIS may ask, you can build your file proactively and reduce the chance of a stressful surprise. Now let's get to the action plan. This is the part to focus on if you want practical steps. First, if you have not filed your I-485 yet, do not file until you confirm you are using the current edition of the form directly from uscis.gov. Check the edition date on the USCIS form page and make sure your form matches. Second, verify support documents using the latest standards. For family-based cases, make sure the I-864 Affidavit of Support is completed correctly and uses the current year's applicable guidelines and supporting evidence, as described in the official instructions. If you're not sure, get qualified help before filing. Third, confirm your medical exam rules before you submit. Form I-693 requirements and validity rules have changed over time and can depend on the policy in effect and the timing of the civil surgeon's signature. Make sure your I-693 is properly completed, properly sealed, and valid under the current USCIS guidance at the time you file. An invalid or improperly prepared medical can create major delays. Fourth, build your evidentiary package before filing, not after. This includes your passport biographic page, evidence of lawful admission, I-94 records, prior approvals, and a clear record of your immigration history. For many cases, having tax transcripts, employment verification, and complete copies of underlying petitions and prior RFEs can help. If there are gaps, changes of status, or prior violations, do not guess. Document and get legal guidance. Fifth, if you are relying on an EAD based on a pending I-485 through Form I-765, understand that problems with the I-485 can affect related benefits. If an I-485 is rejected or denied, it can impact the EAD. If you're working, coordinate with your employer's HR or legal team and make sure you understand your options. Sixth, track the Visa Bulletin and USCIS chart selection monthly. The Department of State publishes the Visa Bulletin around the middle of each month for the following month. USCIS then indicates whether it will accept dates for filing or final action dates for adjustment filings. Those are different charts, and confusing them causes filing mistakes all the time. Seventh, if your case has any complexity at all, prior status issues, prior violations, arrests/charges, prior removal proceedings, prior denials, tricky travel history, AC-21 portability, or anything you're unsure about, consult a qualified immigration attorney or an accredited representative before filing. Yes, legal fees can be expensive, but an experienced professional can spot problems early, help you file correctly, and draft responses that match what USCIS is actually asking for. There are also nonprofit legal services in many areas that may offer low-cost or free consultations if you qualify. Eighth, protect yourself from immigration fraud. This is urgent. During periods of change, scammers and unauthorized practitioners often target immigrants. Some present themselves as notarios or consultants and charge significant fees while giving incorrect advice or submitting improper filings. Only licensed attorneys and BIA-accredited representatives are authorized to provide immigration legal advice. If someone cannot show you their attorney license or accredited representative status, do not let them file your case. Now let's zoom out. Where does all this go for the rest of 2026 and beyond? On the legislative side, proposals may continue to move through Congress, but many will not become law, and timelines are uncertain. Even bills that pass one chamber can stall later, especially in the Senate. At the same time, Congress sometimes advances immigration-adjacent provisions through appropriations or other vehicles, so outcomes can be unpredictable. We will cover verified developments as they happen. On the regulatory side, proposed rules can affect topics like public charge standards, definitions tied to benefits, and how USCIS evaluates certain prior immigration issues. Proposed rules go through notice and comment. Courts can and do block rules through injunctions, and litigation can create periods where rules are in flux. That uncertainty is exactly why accuracy and timing matter if you're eligible now and your priority date is current. But remember, the message is not panic. The message is precision and timeliness. I want to close with this clearly. Immigration status is not just paperwork. It's the foundation families and workers build their lives on. It affects whether parents can stay with children, whether professionals can keep careers they've invested years into, and whether people can live with stability instead of constant uncertainty. The I-485 process, bureaucratic as it is, may be the most important filing many people ever make. Taking it seriously is not optional. Getting it right matters. If you're in this process, you're not alone, and you're not powerless. You can file carefully, document thoroughly, respond to USCIS requests on time and with substance, and get professional help when the issues are complex. The system can be difficult, but it is navigable when you're informed. If you want accurate, fast, and reliable immigration updates, subscribe to Legal Focus USA and turn on notifications. Immigration policy and USCIS practice can change, and staying informed is essential. And before you go, please do 3 things. Hit the like button if this video gave you information you didn't have before. Leave a comment with your visa category or the specific part of the I-485 process you're navigating right now. We read the comments and use your questions to shape future videos. And share this video with someone you know who is filing or planning to file, because they may be relying on outdated information, and that can change outcomes. This is US Entry Updates. We'll see you in the next video.